Good morning, ladies and gentlemen. I'd like to welcome you to County Court at Law number 2. My name is Judge Terrence Holmes. I'm the presiding judge here in County Court at Law number 2. You have been asked to come to court today because you have a case in this court. Your case is on our arraignment docket. Now, the arraignment is an opportunity for the court to tell you what you've been charged with, what your rights are, and what your options are concerning your case. Your case is a criminal case. Criminal cases are divided into two categories. They're either a misdemeanor or a felony. Your felony cases are normally referred to as your more serious type offenses, whereas your misdemeanor cases are normally referred to as your petty offenses. If you had a misdemeanor, the misdemeanors are divided into 5 categories. And we'll start at the top. You have the capital murder, you have first-degree felony, second-degree felony, third-degree felony, and a state jail felony. Now, when I use the term serious, for example, I said felonies are your most serious type offenses. Your misdemeanor cases are were normally referred to as your petty offenses. It does not mean that they are not serious. It just means that they are not as serious as a felony offense. And when I use the term serious, what I'm talking about the facts of the case and the possible punishment that you can get if you are convicted of the offense. Now, for example, if you're convicted of a capital murder, well, if you're convicted of a state jail felony, which is the lowest felony, the range of punishment is a minimum of 6 months to a maximum of 2 years in the state jail, and a fine that does not exceed $10,000. If you're convicted of a third-degree felony, the range of punishment is minimum 2 years to a maximum of 10 years, and a fine that does not exceed $10,000. And if you're convicted of a second-degree felony, the range of punishment is minimum 2 years to a maximum of 20 years, a fine up to $10,000. If you're convicted of a first-degree felony, the range of punishment is minimum 5 years to a maximum of 99 years to life, and a fine up to $10,000. Now, if you're convicted of a capital murder, which is the highest felony, the range of punishment is life in the state penitentiary without the possibility of parole or death by lethal injection. Now, you don't have to worry about that because you have a misdemeanor case. Misdemeanors are divided into 3 categories. We're going to start at the top. You have the Class A misdemeanor, the Class B misdemeanor, and the Class C misdemeanor. Now, the Class C misdemeanors are offenses that's normally handled in the JP court or the city court, the municipal court. Those cases come to this court when somebody is convicted in the JP court or the municipal court, and they appeal their case. It comes to this court, County Court at Law. Now, the range of punishment for a Class C misdemeanor is by fine only. You cannot be given any jail time. You only could be given a fine. Normally, the fine does not exceed $500. Now, if you fail to pay the fine, we can convert it to community service. And if you fail to perform the community service, then at that point, the court can issue what is called a capias pro fine. It's a warrant for your arrest to pay the fine or to sit out the fine, okay? We call that a capias pro fine, which means you can sit out the jail time to pay off the fine and the court costs. Now, the next misdemeanor is a Class B misdemeanor. The range of punishment for a Class B misdemeanor is a minimum of 0 days to a maximum of 180 days in the county jail, and a fine that does not exceed $2,000, or you could be given both such fine and confinement. If you are convicted of a Class A misdemeanor, the range of punishment is a minimum of 0 days to a maximum of 365 days in the county jail, a fine from $0 to $4,000, or you could be given both such fine and confinement. Now, as a defendant in a criminal case, you have rights. And I'll go over some of the rights, which one of the rights that you have is the right to have an attorney. Now, the first document on the clipboard that you have is titled Judge's Explanation of Rights to Defendants Without an Attorney. On that document, it talks about your rights to have an attorney. For example, it states, as a defendant in a criminal case, you have 3 options regarding your right to have an attorney. Number 1, you may hire an attorney. Number 2, if you cannot afford to hire an attorney, you may request that an attorney be appointed to represent you. Or number 3, you may give up your right to an attorney. We say you may waive your right to an attorney. That means give up your right to an attorney, and you may represent yourself. Now, if you want an attorney to represent you and you have enough money to hire an attorney, the case will be reset. Reset means you'll be given another court date so that you will have time to hire your attorney. If you want an attorney, but you do not have enough money to hire an attorney, you will need to fill out a financial questionnaire. Now, the financial questionnaire is a document, should be the last document on the clipboard. The last document on the clipboard is titled Jefferson County Affidavit of Indigence. That's the financial questionnaire. You need to fill out that financial questionnaire so that the proper person can determine whether or not to appoint an attorney to represent you. Now, if you want to waive your right to an attorney or give up your right to an attorney, and you want to represent yourself, you cannot speak to the prosecutor. The prosecutor is the person that is the assistant district attorney. It works for the district attorney's office. We call them the prosecutor. Now, if you want to represent yourself, you can talk to the prosecutor, but you cannot talk to the prosecutor unless you first sign a written waiver of your right to be represented by an attorney. Now, the written waiver is the second document on the clipboard, and it is titled Waiver of Counsel for Purposes of Entering a Guilty Plea or Proceeding to Trial. Now, be aware that there are dangers to self-representation. If you want to represent yourself and waive your right to an attorney, be aware that there are dangers to self-representation. Waiving your right to an attorney and representing yourself may result in a worse outcome for you and your case, including the loss of significant rights and opportunities relating to military service, possession of a firearm, housing and public benefits, child custody, immigration status for non-citizens, and employment. If you choose to proceed without an attorney, that is, if you decide you want to waive your right to an attorney and to represent yourself, you may change your mind at any time and request that the court appoint an attorney to represent you. Now, at the bottom of that document, that first document, there are 5 lines, excuse me. The first line states that I want to reset my case to hire my own attorney. So if your desire is to hire your own attorney, then you will put your initials on the first line to the left. If you have already hired an attorney to represent you, then you will place your initials on the second line to the left and the name of the attorney on the line to the right. If your choice is to ask for a court-appointed attorney, then you will put your initials on the third line to the left. If you have already been appointed a court-appointed attorney to represent you in this case, then you will place your initials on the fourth line to the left and the name of the attorney on the line to the right. Now, if you want to waive your right to the attorney or give up your right to the attorney and represent yourself, then you will put your initials on the fifth line to the left. Now, once you have finished initialing one of the 5 lines, Then you will sign your name on the line that is titled defendant, and you will date it today's date, September 26th of 2023, on the line that is titled date. Now, for those of you who will be waiving your right to an attorney and desiring to represent yourself, you would have to read and sign the second page that is titled Waiver of Counsel for purposes of entering a guilty plea or proceeding to trial. At the bottom, now I'll go over this document with you, and it states, I have been advised of the nature and charges against me and the dangers and disadvantages of self-representation. My waiver is voluntarily, meaning that voluntarily means that nobody is forcing you to do this. You're doing it on your own. And it says it's voluntarily and intelligently. Intelligently means that you know what you are doing. Okay? Furthermore, I have been advised this 26th day of September by the County Court at Law, number 2 of my right to representation by counsel in the case pending against me. I have been further advised that if I'm unable to afford counsel, one will be appointed for me free of charge. Understanding my right to have counsel appointed for me free of charge, if I'm not financially able to employ counsel, I wish to waive that right and request the court to proceed with my case without an attorney being appointed for me. Now, if that's your choice, it also says, I hereby waive my right to counsel. And if that is your choice, you will sign your name on the line that is titled defendant, and you will date it today's date, September 26, 2023. Now, as a defendant in a criminal court, in a criminal case, you also have a right to have a jury to sit in, to listen to the evidence in your case. Now, when a young lady is sitting in that area over here, we call it the jury box. 6 citizens from Jefferson County will be selected as jurors in your case. They will listen to all of the evidence, they will listen to the arguments, they will deliberate, and then they will decide whether to find you not guilty or guilty. You also have a right to waive or give up your right to have a trial by jury. And by waiving your right to have a trial by jury, you will not be having a trial by jury. And because you will not be having a trial by jury, your case will come before the court in one of 3 ways. One way it will come before the court is by way of a bench trial. A bench trial means that you will not be having a trial by jury, you will be having a trial by judge. And the judge will listen to all of the evidence and all of the arguments, and then the judge will decide to find you not guilty or guilty. Now, if you decide that you didn't want a trial, your case will come before the judge by way of a plea bargain. It can come by way of an agreed plea bargain. And what an agreed plea bargain is, it means that you and the state have reached an agreement to settle your case. We call that a plea bargain agreement. And that agreement will come before the court or before the judge. And then the judge can either accept the plea bargain agreement or reject the plea bargain agreement. Now, if the judge accepts the plea bargain agreement, if you decide that within 30 days that you would like to appeal your case, that is, you would like to have a higher court to review your case because you think that, one, you may have been wrongly convicted, or this court has committed an error by convicting you. And so therefore, if you want to appeal your case, then you would have to get permission from the judge that followed the plea bargain agreement. And then if the judge gives you that permission, your case will go to the Ninth Court of Appeals, which is right above us on the 3rd floor. They will review your case to see whether or not you've been wrongly convicted or whether or not this court has committed an error by convicting you. And the Ninth Court of Appeals can do one of 2 things. They can either grant your appeal or they can deny your appeal. If they grant your appeal, then they can just simply find you not guilty, or they can send the case back down to this court and order this court to give you a whole new trial. Now, if they deny your appeal, you can appeal your case to a higher court than the Ninth Court of Appeals. You can appeal it to the highest criminal court in the state of Texas. And that case, well, the highest criminal court in the state of Texas is located in Austin, Texas. It's called the Texas Court of Criminal Appeals. Now, you would have to file what is called a pro se petition for discretionary review. Pro se means you'll be filing this on your own. And by filing it on your own, that just simply means that you will not have a lawyer representing you because you will be representing yourself. They will review your case. They could either accept, or meaning that they can either grant or they can deny your pro se petition. If they grant your pro se petition, they can simply find you not guilty, or they can send the case back to the Ninth Court of Appeals or to this court ordering us to give you a whole new trial. If they deny your pro se petition, then at that point, your conviction will stand. Now, next, you have a right to have what we call, you have a right to enter into what is called an unagreed plea. What an unagreed plea means is you and the state have not been able to reach a plea bargain agreement. So therefore, you want the judge to assess your punishment. Now, and the judge could, assess your punishment anywhere within the punishment range. The other right that you have a right to have witnesses to come to court. And what witnesses do, they'll sit in this chair over here that we call the witness stand, and witnesses will testify. They can testify for you or against you. If you're representing yourself or if you're represented by an attorney, questions can be asked by you if you're representing yourself, or by your attorney if you're represented by an attorney. We call that either direct examination or cross-examination. You also have a right to waive or give up your right to have witnesses to come to court in your case. By waiving or giving up your right to have witnesses in your case, what that means is you will not be calling witnesses in your case. It does not mean that the state will not be calling witnesses, because the state will be calling witnesses. You also have a Fifth Amendment right against self-incrimination. What that basically means is the state cannot force you to testify in your case. So you have a right not to testify in your case. So the state, the government, the district attorney's office cannot call you to the witness stand to testify in your case. Now you can waive, which means to give up your Fifth Amendment right to against self-incrimination and testify if you desire to do so. You also have a right to have what we call discovery. Discovery means you have a right to see the evidence that the state has against you. And you have a right to see documents, you have a right to see reports, witness statements, your statements. You have a right to see videos or listen to audio recordings, or examine any instruments that the state may be using as evidence in your case. You have a right to have access to that. Now you can waive, which means you can give up your right to have discovery as well. Now, if you waive or give up your right to have discovery, what that means is you will not be having access to the evidence that the state has against you. Now, everyone that's here today for a case, you've been called here, you're here for an arraignment, you've been arrested. And every day that you have spent in jail can be used as credit towards your punishment. So for example, if let's say you spent 5 days in jail, and the state and you have reached a plea bargain agreement, and that agreement is for you to serve 5 days in jail, that simply means you will not have to serve any more time in jail. Why? Because you've already served 5 days in jail. Therefore, you'll be given credit for the time that you have already served. Also, if the state is offering 7 days for you to serve in jail and you serve 5 days in jail, that simply means that you will only be required to serve 2 days in jail, because why? You will be given credit for the 5 days that you've already served. Every day that you spent in jail can also be used as credit toward your fine and court costs. Every day that you have spent in jail, $100 will go toward your fine and court costs. So if you spent 5 days in jail, that's $500. And so if you and the state has reached an agreement for you to pay $500 court fine and court costs, you won't have to pay anything. Why? Because the $500, the 5 days that you spent in jail has already paid it off. Therefore, you'll be given credit, will be taxed and retired, and then you will not have to pay it. Now, if you spent 5 days in jail and the state is offering fine and court costs of $700, that simply means you would have to pay $200 on the day that you dispose of your case. Now, if you cannot pay the $200, then the court can convert the remaining $200 balance to community service. It can be converted to community service. And what that means is you can work at a nonprofit organization to pay off the community service. Now, every hour that you work at a nonprofit organization, $12.50 will go toward your fine and court costs. So, for example, in the scenario that I just given you, $500, I mean, with you're paying $700, but you spent 5 days in jail, so that remaining balance of $200. If you work an 8-hour day, that's $100 that will go toward your community service. And so in this scenario, you work 2 days, that's $200 that will go toward your community service, 2 8-hour days. Now, Jefferson County has a program that is called pretrial diversion. Pretrial diversion is for individuals who have, well, first of all, with pretrial diversion, they would dismiss your case and you can get it wiped off, expunged, deleted, or erased from your record. And in order to get into the program, you have to, first of all, you have to be your first offense. It cannot be an offense for resisting arrest, unlawfully carrying a weapon, and you have to have an attorney to assist you at getting into the program. If you get into the program, then once you get into the program, they will dismiss your case. Once you complete the program, then you can get it expunged, erased, or deleted, or wiped off your criminal record. Now, if you are a veteran of any one of the military branches, Jefferson County has a program that is called Veterans Court. It's for veterans only. It is also part of the pretrial diversion program. With that program, you get into the program, complete the program, and then you can get what is called the case will be dismissed, and you'll get what is called a non-disclosure. A non-disclosure basically means that the fact that you was in this program and had this case cannot be disclosed to the general public. Now, governmental agencies can have access, but the general public cannot have access to the fact that you had this case and that you were in the pretrial diversion program. Now, this court has a program that is called the CSI program. The CSI program stands for Community Safety Initiative. It is a program that I started within the first 100 days of taking office in March of 2017. That program is designed to address the issue of what we call recidivism. Recidivism means when people commit crimes over and over. And so with this program, the program is designed to address the issue of recidivism and make Jefferson County a safer place for all of us to live, work, go to school, raise our families, and go to church. Now, the way the program works is we have partnerships with local agencies. One of the agencies that we have a partnership with is Spindletop. The young people that's sitting in that jury box, they're from Spindletop, and they're going to come to you in a few minutes and tell you something about the program that they have to offer. But the program that we have with Spindletop, now Spindletop is our local mental health center. The Spindletop Center is our local mental health center. Now they are able to do well, first of all, they'll do private interviews. They'll conduct a private interview. And with the private interview, it can either be here in the court house, in our jury room, in a private setting, or it could be at their facility, or they may be able to conduct it by phone. Now, they can also conduct what is called an assessment to determine what your mental health needs are. Now, you do not have to be incompetent or insane. They can address, because they will address issues such as anxiety, depression, and a whole host of other issues that a person may have. Now, once that's done, then they can develop a treatment plan, either outpatient or inpatient, to address your mental health needs. If you have issues with drugs or alcohol, then we have a partnership with Spindletop that has a program that is called ATAR. And we also have a partnership with the local Drug and Alcohol Council that has a program that is called OZAR. ATAR stands for Addiction, Treatment, and Recovery. OZAR stands for Outreach, Screening, Assessment, and Referrals. All of those programs basically are similar in that they will do a screening, an assessment, and then you will be given a treatment plan, either outpatient or inpatient, to address your drug or alcohol issues. Now, if you are unemployed or looking for a better job, then we have a partnership with the Golden Triangle Empowerment Center, who has a partnership with Lamar University. Lamar University has a program that is called CICE. CICE stands for Center for Innovation, Commercialization, and Entrepreneurship. It is a job training and a job placement program in the hotel industry, the shipping industry, and the chemical industry. Once you are trained in one of the areas that you select, then you will be trained in that area. And once you're trained in that area, they will assist you at getting a job in the area that you're trained in. If you have not graduated from high school and you would like to get your GED, CICE has a GED program where you can get your graduate equivalency diploma. Now, all of these programs that I just mentioned to you are free. It does not cost you or the county 1 cent. Only thing you have to do is have a desire to be in the program and take the time to participate in the program. And speaking of time, in this court, we do not just give time, we take our time. And that simply means we do not just arrest the problem, we address the problem. And we believe by addressing the problem, we can produce productive people. And if we produce productive people would not commit crimes. Why? Because they have too much to lose. And so therefore, I always say that when you come to county court at law number 2, we do not just have court as usual, we have unusual court. And it's not because we're different, but it's because we're trying to make a difference in the lives of the individuals that come before this court. And if we make a difference in the lives of the individuals that come before this court, we will also make a difference in their home. And if we make a difference in their home, we will also make a difference in our community, because what goes into the community comes out of the home. And so if you're interested in any one of these programs, just let us know. We have brochures that we can give you to assist you to get into these programs. And as I mentioned earlier, we have the folks from Spindletop, we have Deputy Hinton and Gabby, who is going to come forward and tell you a little bit about the program that they have to offer at Spindletop. Deputy Hinton and Gabby.
Thank you, Your Honor.
You're welcome.
Good morning. My name is Steve Hinton. I'm a mental health deputy licensed by the state commission with the sheriff's office. This is my coworker here, Gabby. Now, Gabby is a qualified mental health professional at Spindletop. The reason we are both here this morning is because the judge has graciously invited us to his courtroom because he cares that every single person comes to the bench. What the judge has found, and what statistics prove, is those who have legal issues commonly have mental health needs, substance use disorders, or sometimes just a lack of community resources to help you with the situation.
So what it means like mental health needs, this can be just common anxiety or symptoms of depression or deep sadness that doesn't really get better since you're in the sport. Being in the sport proceeding, having a charge is a lot and it is heavy on you, we can understand. And so it can be from resources such as like food or employment, we can help you with that, but also if you just need support, especially during this time, we offer that.
So maybe this is your first time being here, maybe it's your 10th time to be here, there's still hope. What we're offering you today has the ability to change your life, but we're gonna need something from you. And when you walked in earlier, Gabby gave you a piece of paper, and she's gonna tell you how you can use that to share that need with us very privately. We're not here to embarrass anyone, but we are here to help you if this is something that you see a value in and that you can take advantage of.
Well, I do see we have a lot of like parents or support systems here. That's not only for the person who is coming to court, but it's also for the family too, or anybody that you know to who need help, or just any resources or have a need. So with this is going to be shared on here. This is a HIPAA consent. This just means that this is not being shared with anybody except for us. This does not go outside of us, and our information, your information does not get sent around. And whoever said, with this allows us to just contact you once. And the first matter is going to be by text message, and it's going to be from me, Gabby. So if you receive a text message, it's going to be within this week. And it's going to ask, hey, if you would want to talk on the phone, or would you like me to schedule that for you also? But if you just have a need, that's when I'll be able to talk to you and share it with you. And so with that, just make sure you put right here the phone number for us. And also, there's going to be a line that says what general resources do you need. It just means what needs, what is there something that's missing in your life that we can try and help with. And you just fill it out on your phone.
And before you leave here today, I also want to give you this flyer and get it in everyone's hands. On the back of it, it gives you some advantages for participating, but it also has a 1-800 number. Should you ever find yourself in an unsafe place, you can call that number and get help immediately. And just shortly, the court is going to go into recess, and when it does, we'll be coming out there. We'll be visiting with you, have time to talk to you, and we'll also pick up those forms for those who want to turn them in, and I'll also hand this to everyone who wants one as well. Thank you very much.
Okay.
Thank you, Your Honor.
Okay. Thank you, Deputy Hinton and Gabby. Now, ladies and gentlemen, the paperwork that you have on your clipboards, if you need any assistance in filling out that paperwork, we have our court personnel who will be here, or who's here to help you with filling out the paperwork. Now, it's going to take some time for us to pick up the paperwork from you. And then once we pick up the paperwork from you, then we have to go through that paperwork. Once we finish going through the paperwork, we're going to call you up to the bench one at a time to go through your paperwork. And if you need to use the restroom, there are 2 restrooms right outside the courtroom. The men's restroom is in front of County Court at Law number 3. And the women's restroom is across the hall, right in front of the 176th Second District Court. Now, please do not leave the courthouse. Because if you leave the courthouse and your case is called, and if you're not here, your bond will be forfeited, and if your bond is forfeited, then a warrant will be issued for your arrest. You'll be arrested and placed in the Jefferson County Jail. So at this time, we're going to go into recess to give our court staff an opportunity to assist those who need help with their paperwork and to pick up the paperwork from you. So at this time, the court will be in recess